Good morning, everyone. Thank you so much for joining us today for our latest webinar focusing on a legislative update. Today's presenters are Patrick Charles, PARAC's Associate General Counsel, and Bill Keefe, PARAC's Associate Deputy Director. Just so you know, today's webinar is being recorded and it will be available at a later date on our website. Board members who are attending live will automatically receive their 3 credits. You do not need to do anything. Rose will get the attendee list and she will update your account in Prosper. If you have questions during the presentation, Bill and Patrick are not going to take questions as they speak. They will take all the questions at the end, but please type in your questions. There's a field on the sidebar for GoToWebinar where you can type in your questions, and at the end I'll be reading off all the questions, and it's best if you just type them in as you think of them, and we will answer as many as we can throughout the presentation. If you would like to download the handout, it is available. There's a handout tab also on the GoToWebinar login here. Just click on the presentation. There's a PDF that you can download to your desktop and you can follow along with us as we present. So without further ado, I'm going to hand it over and turn off my cam and let Patrick and Bill take over. Thank you so much.
Good morning, everyone. As Natasha mentioned, Bill and I are going to do a legislative update for you today that's going to consist mainly of 2 parts. The first part being an update on special legislation, the types of special legislation that you may see as board members and as board staff, because there are a number of bills that get passed each session that deal with individuals or small groups of people, and that will have an impact on their benefits and will be necessary that you understand how to look at these bills and what parts to look for to make sure that all of the provisions of the bills are implemented. And then the second part, we will go over PARAC's legislative agenda. Each session, PARAC files a number of bills seeking to amend Chapter 32 or in some way address an issue that has come up in the previous 2-year session. And this year we have actually 8 bills, which is a fairly aggressive agenda for us. Unfortunately, a number of our bills from last session really didn't get much traction with the COVID shutdown of the State House, and a lot of the session was sort of truncated by the response and the state of emergency. So hopefully we'll get a few more bills moving this session, but we'll go over those in a moment. As Natasha mentioned, we'll take questions at the end, so please type them in on the right-hand side there, and we will try to answer as many as possible. With that, I'm going to turn it over to Bill to start talking about special legislation.
All right, thank you, Patrick. If we could just bump the slides up, Tasha. Patrick's clearly a rock star in this community. I'm still the new kid on the block. I've been around for a little more than a year, but with the pandemic, obviously the chance to get out and meet people hasn't been there. So I just wanted to quickly introduce myself. I worked at the state auditor's office for a long time, more years than I want to say, before coming over to PARAC. We had exposure to a wide array of state agencies and laws, and I have to say that Chapter 32 is more difficult than having exposure to all those different wide array of laws. It's definitely very complex, and hats off to all of you practitioners, and it's been great to learn about it and work with people on that. So special legislation, it's a term that kind of gets thrown around. What is it? It comes back to general laws. So general laws are codified. They're broadly based. They have broad application. A session law is a law that's passed during a year of the legislature. An example of a general law, Chapter 32, Section 20, Mass General Law, Chapter 32, Section 20. A session law is a chapter, and I'm just making this number up, Chapter 842 of the Acts of 2020. A general law gets passed as a session law, but a session law is not necessarily a general law. A session law could create or amend a general law, but it doesn't have to be a general law, whereas a general law gets passed as a session law. One more slide ahead, please. Special legislation is special in that it it creates an exception to something that's already that's not authorized. It has narrow application. It doesn't create or amend general law. One example is this past year with the COVID emergency, Chapter 53 of the Acts of 2020 had a number of emergency applications in relation to the pandemic. One particularly waiving the earnings and hours maximum for people that work after retirement in the public sector. Another is obviously Chapter 176 of the Acts of 2011. In that case, that did amend general law, mostly Chapter 32, but it's such a landmark piece of legislation with so many different factors, and it has specific dates in it that people often reference it by that title of Chapter 176 of 2011. Okay, so it creates, an exception, and it addresses emergency situation, and just by its nature, as we're saying, it is indeed special. That's what makes it special legislation. It's not something that is broadly based. It doesn't go into the general laws. It's a narrow application. It has special circumstance around it. One example, and Irene Triplett is a favorite of Judith Corrigan in explaining how pension obligations can last a long time. She was the last Civil War pensioner. She just passed away this past year, God rest her soul. And so in trying to just have a similar example as to what the effects of special legislation could be, I saw this one, Chapter 421 of the Acts of 2018. It amended a bill, a special piece of legislation from 1983. It dealt with an accident that occurred in 1978, and it was for a police officer of the former MDC, the Metropolitan District Commission. I'm sure plenty of us remember and know the old MDC, but maybe for some of the younger folks, the MDC was the precursor to the Department of Conservation and Recreation. It was a legendary place. When the building on Somerset Street was taken down, they were found all kinds of relics and trinkets and who knows what, all kinds of historical government artifacts. There's a rumor that former Governor's Counselor Mike Callahan had a little lair down there where he'd hang out. Mike was a great guy, funny guy. He just actually passed away 10 years ago this month. I was looking him up and thinking about this, and but he was the type of guy that might be hanging out at the MDC building, just saying. So in looking at the last 3 years, we're just kind of looking through what were the specific laws that passed and what were the most common. Maximum retirement age, allowing somebody to work past the mandated age of 65 for a public safety employee. There were 25 laws that allowed somebody to work past that age. There were 4 laws about enhancing disability benefits. Those are the 2 that we're going to speak about most because they have the most variance and the most application. The remaining laws that were special legislation tied to retirement involve veterans buyback, which is usually pretty straightforward. Survivor benefits, purchasing of non-military time, a couple of bills, a couple of laws allowing a group of employees to transfer or join a retirement system. We just actually worked on one now with the State Retirement Board in Hampshire. The Hampshire Council of Governments was an organization that filled the void after Hampshire County was dissolved, and now Hampshire Council of Governments is being dissolved. And there was a lot of work done to transfer those folks into the State Retirement Board. Things about special legislation, it's a home rule process. It gets done locally. I didn't realize this until just recently, but I guess you folks, the retirement board folks, aren't always tipped off or consulted by the local folks who are drafting these things. I'm sure that would be a benefit to you to have that heads up, but I guess that doesn't always happen. They're difficult to amend. When they come to the legislature, they can either, it depends on the community that's forwarding it and what stipulations they attach, but It can sometimes only be amended for technical changes. Sometimes significant changes have to go back to the city or town. So it can get a little bit hairy. It creates expectations. It's almost like a contract. It lays out the specifics of what's going to happen with that person, whether it's about an enhanced disability, whether it's about maximum age. We strive for uniformity. We try to have that level playing field, but the details can vary, and that's something that we're going to go into now with a couple of examples of laws that passed. This is Chapter 117 of the Acts of 2020. It allowed, it enhanced disability benefits for a Salem police officer who was injured in the line of duty. As you can see, he was injured in October 2014, and it took nearly 6 years for this benefit to pass, for this law to pass. The first thing that we look for, and I'm sorry if you can hear it, they're building a dormer next door to my house, so I'm hoping that the hammering isn't coming through, and there's nowhere else I can go to escape it. So I'll do my best to try to talk over it, I guess. We look for sections 8 and 91 that they are applicable. In this law, section 8, subdivision 2 of it is specifically mentioned. It's actually superfluous. If it's not mentioned, then it's understood that it applies. But occasionally there are bills that say section 8 and 91 don't apply. We try to avoid that from happening. We try to, again, like we talked about the level playing field, and there's already a enhanced benefit here. It seems it's only fair that they still have the disability hours, the hours and earnings restrictions placed on them, that they go through the return to service process. If they ever did want to return to work, if their situation changed, that's really the only way to go through it. So, so sections 8 and 91 are two things that we look for. The next thing is the rate of pension. In this case here, it says he should be paid had he continued in service as a police officer at the grade held by him at the time of his retirement. There can be variations. It could be a percentage. So it's just something to look for. It's something that spells out specifics of this contract, as we said. The next thing is tax-free. We know that disability pensions are tax-free, but sometimes we try to catch this or have it amended. Sometimes they'll say all amounts are tax-free, and the state doesn't have the power to dictate that the federal, there won't be federal taxes on it. So we try to have it worded like this if it's going to be spelled out, that non-taxable to the extent allowable under state and federal law. On the state side, it will be tax-free, but on the federal side, it won't be. And then in clause C here, it mentions section 7. That's a key point for it being tax-free. It specifies it's a disability pension. If there were ever questions with Department of Revenue, IRS, it's something that would help out. And it also, this states that upon reaching mandatory retirement age, there'll be a pension, and it sets out what the percentage is. In some cases, there isn't a pension set at mandatory retirement age. Some people receive full compensation all the way through. That's a little more rare, but usually there is the mandatory retirement age and the pension, and there's a percentage set. Another thing that we look for is that return of the retirement deductions. As we just saw in that odd special piece of legislation from the 80s, that they left out the return of the retirement deduction. So it's good to see that this one here in section 3 of this bill is spelled out, that the retirement deductions get returned. Then we get into survivor benefits, spelling out that, should this person pass and is married, that the survivor will receive what percentage of pension. And further, it states that both the survivor benefits and the benefits to the injured officer are subject to the COLA. So it's good to have that specified. And then the last piece on this slide is that should either parent pass and the children be a certain age, or if the child has, medical issues, that the benefit would continue to the children under the circumstances dictated here. Another thing that we look for and we try to ensure is that all disability retirees go to a medical panel. There are times that the person has already gone through a medical panel and they're already receiving a disability, and the statute is enhancing their benefit. In this case, this person had been on 111F, had continued to receive salary, and this was their retirement. So we wanted to make sure that the person had gone to a medical panel. And the last piece is the date of effectiveness. Sometimes it'll say take effect upon passage. Other times it could be retroactive, in which case there'd be a retroactive payment. So it's something to keep an eye on as to what the date of effectiveness is, and it's usually the last piece of it. There are sometimes with other laws emergency preambles. We won't see those on this, but you will see either actual take effect upon passage, or there could be a retroactive date, or if not, then it would just take effect in the normal course of other laws too. So just to sum up, the things that, to keep an eye out, and the things that we look at when we're reviewing bills, or when the legislature asks us to weigh in on these types of things, is the application of Sections 8 and 91, the rate of the pension, reference to Section 7, the tax-free language, making sure that it's not just a blanket tax-free. We try to see it to the extent allowable under state and federal law, the pension at the maximum age, deductions. I don't want to be reading all the slides, I'm sorry, but that is the summary of what we're looking at when we look at disability special legislation. Moving on to maximum age legislation. This is again where usually police or fire is allowed to work past 65 through this special legislation. The age 65 is a personnel, it's a state HRD, human resource issue. It's not a pension issue. I know we run into cases, especially out in Western Mass, with call volunteer departments, smaller populations, rural, where they're running up against this quite a bit. And even though they're often not members of the retirement system, the issue is not a pension issue. It goes back to Chapter 415 of the Acts of 1987. So we've actually talked with Rep. Blaze of Sunderland about this. She may be filing a bill to try to create a blanket exemption for members who are not part of a retirement system to be able to work past 65. But again, that's just FYI and conversation. It's not anything at this point. But so as you see, the first part that we have highlighted here is the date that the person is allowed to work till. We've tried to hold the line with age 70, 65 is what is in statute. That no further deductions be taken. Once a person is age 65, there's no further deductions, because the pension should be calculated as if when the person reached age 65. And lastly, again, that date of effectiveness is, could be retroactive. It could be taking effect upon passage. And just to recap on the maximum legislation, maximum age, it's the date that the service must end, no further deductions past age 65, the calculation of the pension as of age 65, and the effective date. So a couple other types of special legislation we just touched on earlier when I kind of gave the numbers of how many had passed in the last few years. Veterans buybacks, we'll get into this a little bit more when we talk about the PARAC legislation. Direct and credible service, there are certain bills that have passed directing or authorizing a retirement board to allow the purchase or grant credible service for non-military time. Those are more rare than the veterans buyback bills. Sadly, there are a couple of death benefit bills that have passed. There's one early retirement program I saw in the last 3 years. I'm sure in the past there have been others. And then in terms of joining, I mentioned the Hampshire Council of Governments earlier, and there was another law in the last couple of years that allowed Western Mass Emergency Communications to join Hamden. So those are the kinds of the things that we've seen pass over the last 3 years. And with that, I'm going to turn it over to Patrick and come back in a little bit.
So I'm going to talk about the first few bills that PARAC has filed as part of our legislative agenda. On this slide, you'll see that we have 8 bills listed. I'll cover the first 5. All of these 5 are actually refiles from the last session, and they have all come about because of addressing specific situations. What often happens at PARAC is we will either be involved in a case or see cases that have an outcome that is contrary or that raises an issue with some particular provision in Chapter 32. And we will go to the commission and ask to file legislation to amend something, amend Chapter 32 in some way to shift that back or to make a change, because in some instances, the cases present us with a situation that we did not consider, that had not been considered prior to that case. We'll go to the first bill, which is an act relative to pension forfeiture. And this is actually one that definitely came from a case. It came from the Betancourt versus PARAC case, which was a pension forfeiture case that took, I believe, approximately 8 years from start to finish to actually get to a decision from the SJC. Mr. Betancourt was a lieutenant in the Peabody Police Department. He was convicted of 21 crimes related to his officer position. They were largely computer-related crimes. He had been creating false accounts to view civil service scores, and he had done so from the station house where he was, in fact, at the time he did it, he was in command of the police station on that particular night. It went back and forth many times. The board attempted to approve the benefit. We told them that they needed to forfeit. It went through Superior Court and everything. So finally, it was determined it was related to his office position and he was subject to forfeiture. But then the issue became the 8th Amendment. The 8th Amendment to the US Constitution outlaws excessive fines. And no other court had ever said that a forfeiture under a pension statute was considered an excessive fine, or even a fine, in fact, for purposes of the 8th Amendment. And the Betancourt SJC decision, in fact, held that it was, that pension forfeiture is subject to the excessive fines clause, and that in Mr. Betancourt's case, his forfeiture was considered excessive. The amount listed in the case is about $660,000 in pension benefits, and then an undetermined amount in healthcare, because when you lose your pension under Section 15, most people then lose their health insurance, because health insurance for retirees is tied to being a retiree, to that status. And if you are excluded from being a Chapter 32 retiree, you are also generally excluded from municipal and, in particular, state health insurance. So the Pension Forfeiture Commission was created by the legislature in 2016. Chapter 133 of the Acts of 2016, and this commission was tasked with addressing any possible changes necessary to the pension forfeiture law to encompass the Betancourt decision, because what was the fear is that a large number of pension forfeitures would not go forward because the amounts would be high enough that pension forfeiture would be considered an excessive fine. And one of the concerns is that, well, okay, Mr. Betancourt had a $660,000 assumed pension. What about someone who's only getting paid $40,000 a year or $30,000 a year? Their benefit is always going to be much lower. What would the analysis be for them when they're looking at a $250,000 lifetime benefit? Is that going to end up being excessive, and how is that going to be determined? The Pension Forfeiture Commission looked into a number of things. The commission compared multiple states, especially focusing on non-Social Security states, because Massachusetts, like 5 other states, is entirely exempted from Social Security for public employees. Many other states, their state employees are in Social Security, but their teachers are not in Social Security. but there are 5 others that, like us, no one is in Social Security. That means that the pension for a public employee is oftentimes the sole retirement benefit that they are expected to receive. If you are a career employee who has never really paid into Social Security in the first place from a private sector job, and you lose your pension, that's it. You have no retirement income. So the Pension Forfeiture Commission released a number of recommendations and actually released a draft bill that they filed. That bill went through the legislature and was amended in public service, and it did not pass, obviously. So PARAC has refiled it for the last 2 legislative sessions, trying to move forward. So I'm going to summarize the basic provisions of that bill. In particular, the recommendation is to redraft. Can you just go back 1 slide, please? To redraft Section 15 in its entirety. In order to accomplish all of the different goals that were presented in the commission, it was best to start with an entirely new Section 15. Much of it is copied back into it. One of the biggest changes that will be obvious is only felony convictions would result in forfeiture. I'm going to go into more detail on some of these, but I just wanted to highlight partial forfeiture is another area that is a drastic change from the current law, because the current law is an all or nothing proposition. If you commit a crime that is relative to your office or position, you forfeit your entire pension. There's no wiggle room. The board is basically mandated to forfeit you. Members with less than 10 years of service would just get a return of deductions. And here is another big issue that has popped up many times with pension forfeitures. Option C pop up for beneficiaries. What do you do with beneficiaries? The beneficiaries may in fact be relying on the pension just as much as the member, and they are going to be held to a very strict standard if forfeiture stays the way it is, and this allows for a little wiggle room there and allows for a possible benefit for the beneficiaries. Also, trying to direct the appeals straight to Superior Court to get rid of some of the layers so that this process can move more quickly. Forfeited members are prohibited from joining the system in the future. This is currently true, but it's reiterated here, and it also in particular applies to the members that are forfeited before they even get a benefit, to make sure that you can't join a second system. We have in fact seen cases where a member was forfeited in one system and then somehow managed to join 2 other systems at various times in his life after he had been forfeited. And then that meant that he had to be forfeited again and removed from membership because he was never legally allowed to be a member of the second and third system. And then there's the question of restitution and how restitution when there's some sort of misappropriation of funds. Next slide, please. So what would trigger pension forfeiture? Currently, it's any crime that you commit that's relative to your office or position. The recommendation is to change that to felony convictions so that minor misdemeanors are not included. We are one of the few states that has a pension forfeiture statute that does allow for misdemeanor crimes. There are actually a number of states that have very, very specific crimes that must be committed. We are much broader in that it is any crime related to your office or position. There are some specific crimes that are also recommended, largely dealing with child pornography and violent sexual offenses involving children, and this would be specific to people whose primary job responsibility involves contact with children. This is obviously something that would pop up most in the school setting because most of those jobs will entail largely contact with children. Forfeiture for members with 10 or more years of service. These are people that we consider vested. So they are, by their nature, guaranteed a right to a benefit by the fact that they have the 10 years of service. So they're treated differently than the person that only has 5 or 6 years of service. And instead of the all or nothing proposition at full forfeiture, the commission recommended, and we have filed legislation to provide for a 1/3, 2/3 pension or a minimum allowance. Now you'll also see full forfeiture listed here. Full forfeiture was not something that was recommended by the special commission, but it was added at the Public Service Committee level in the first session after it was filed, and PARAC has adopted that language and filed it. Now, with full forfeiture, there is a separate set of criteria that needs to be evaluated before full forfeiture can be done. And that is mainly that you need the prosecuting attorney's recommendation that full forfeiture is the appropriate penalty. Now, the other thing here that's unique is the minimum allowance. And what the minimum allowance is essentially, and it will be different for pre-2012 and post-2012 employees. Pre-2012 employees, it's whatever the benefit for a Group 1 employee would be with 10 years of service at the earliest age. That's 55. So it's a 55-year-old with 10 years of service, regardless of whether you have 30 years of service or if you're 60 already. We're going to make you 55 with 10 years of service for purposes of the pension if you get forfeited all the way down to the minimum. If you're only forfeited by a third or 2/3 of the allowance, you're going to use your normal creditable service and your normal retirement age factor. Next slide, please. So how does the board determine what amount to forfeit? There's a number of factors that the board should look at, and under this bill, if it were to pass, it would be the severity of the crime. And in that, you are actually going to look at not just what the actual sentence is, but also what the maximum sentence. So if someone is sentenced to 12 months in prison, but the maximum was 10 years, you would take that into account. Also, sometimes it's a fine. You know, they're fined $500 for each count, but they could have been fined $10,000 for each count. That's something to consider. The monetary loss or financial gain to the member. Some crimes obviously have no financial gain to the member or loss to the system or to the employer. The degree of public trust in the member's position, the role of the member in a fraudulent scheme. Were they in charge of a scheme? Was it a conspiracy with others and they were a minor participant? Then you also look at the recommendation of the prosecuting attorney general or district attorney, and any other factor that the board determines is required by justice. And now the next thing that's different about this is beneficiaries. As I mentioned before, pension forfeiture is an all or nothing proposition. You lose your pension currently, and that's it. You don't get anything, your beneficiary doesn't get anything, your health insurance is gone. Under this bill, the board also looks at, is the beneficiary what's known as an innocent beneficiary? Did they have any role in the crime or in the scheme, the fraudulent activity, whatever the member was convicted of? Did they have any role? Did they have knowledge of it? Did they participate? And if not, then if the member is not fully forfeited and there is still a retirement benefit, the member can retire with an option C benefit, can name their beneficiary for option C, and the member will be paid the forfeited amount. But when that member passes and the option C beneficiary kicks in and starts to take a benefit, they would take a normal option C benefit. So if the member was reduced to a 1/3 pension, the benefit for the option C would actually jump up to the normal 2/3 of the original pre-forfeiture retirement calculation. And what happens with members with less than 10 years of service? Essentially, they are prohibited from being a member of the system, and all they receive is a return of their deductions with 0 interest. Currently, when someone is forfeited under the statute, regardless of the amount of service they have, when they are forfeited, they get a return of their deductions and they get 0 interest, and that is carried over and is in place for anyone with less than 10 years of service. That person with less than 10 years of service will never be able to get a pension from a public pension system in Massachusetts. The appeals process, where the recommendation is to do away with the CRAP and district court, any sort of appeals to them, and go right to Superior Court and get a decision as quickly as possible. Many of these pension forfeiture cases last years. They go through various steps and appeals, and it's just thought that to go right to the Superior Court would streamline the process. And the last part on this bill is restitution. One of the issues that occurs, people in misappropriation of funds, they are stealing money from the employer. They may owe $50,000 that they wrongfully took from the employer. And this allows for restitution from the annuity account of the member. So if the member is a long service employee, they may have 80 or 90,000 in their annuity. They can use that money to pay the fine or the restitution for the misappropriation of funds. If that is the case, then any annuity portion of the retirement allowance would be reduced to reflect the fact that a chunk of the annuity account has been taken away. That is all I have on pension forfeiture. As I've said, this has been a bill that's been around for a while. I do think that pension forfeiture gets into the news every so often, and it's a big issue for a minute or two, but it's often a sort of side issue because there are relatively few pension forfeitures out there. I do think that obviously within the last couple of years, we've seen a lot of issues involving the state police, and some of those members may have already been subject to forfeiture. Some of them may be coming up for forfeiture, as we've seen press articles about people pleading guilty or going to trial on some of those issues. And some of those members may have extremely high pensions if they're long-serving state police officers, because we know that state troopers make a decent salary. And so you could have a $650,000 pension. You could have a much higher pension for a 25 or 30-year employee. And we may see that popping up more as those cases get resolved. The next bill that I want to talk about is an act relative to the recovery of over earnings. This amends Chapter 32, Section 91 to clarify what happens when a member over earns, what happens to their pension, and what recourse does the retirement board in particular have. Currently, when a member over earns under Section 91, your superannuation, you over earn, the statute says that you must return any earnings in excess to the employer. The issue is the employer generally does not take action to seek that money back because the person performed a service for them, so they paid them for that service, and that's the end of it for the employer. The retirement board can step in and take action to recover the over earnings. The issue that this bill addresses is how much can the board seek to recover. PERAC's belief, and I believe the general principle, is that only the amount that's paid in a pension. So if a member receives a $15,000 a year pension, for each year that he over earns, regardless of whether they over earn for $100,000 in that year or just $20,000, you can only take the amount that is owed as a retirement allowance. That has been an issue because the statute itself is not clear. The statute references possibly that it's the entire amount. You cannot earn more than the allowable amount, and if you do, you have to give it all back. But the question is, should the retirement board be getting more money than what they would have paid out? And this actually does stem from another case issue, which was the Daly case, in which I believe this member had a pension of about $10,000 a year. I think he retired to get the health insurance after only 10 or 11 years of service, basically. And he had a private business while he was a public employee, and then he continued that as a retiree. The question was, for a few years, he over-earned. The board estimated that he had earned $400,000 in excess of what he was allowed. In that period, he would have only been paid a pension of approximately $40,000. So the question was, did the board have the right to get the $400,000? And in this particular Daly case, due to other factors, not necessarily related to exactly what the statute says, but just the calculation of the earnings, they did not. But that question still remains open if a better accounting can be done for some of these situations. And so that's why we have filed a bill to move forward and make it clear that it's just the retirement allowance that the boards can recover. The next bill is an act relative to wages. And this is also stems from another case. And in interest of full disclosure, this is a case that I was the attorney on at PERAC for multiple steps of the process and lost every time. So this case involves sick vacation and personal leave taken in conjunction with workers' compensation. So traditionally, it had been the opinion of PERAC, and I think the accepted opinion generally, that if you are on sick to leave, vacation leave, or personal leave, that is regular compensation, no matter when you take it. So if you just take a week off starting tomorrow and then come back to work for the next 10 years, that's regular comp. If you get injured on the job and are on workers' comp, the workers' comp is not regular compensation. That is established law. We were of the opinion, and it had been the established practice, that if you took supplemental pay, so you were on workers' comp, but then you by law are allowed to supplement your workers' comp with your accrued sick and vacation leave, if you did that, it was counted as regular compensation. The Vernava case upended that belief and changed it so that anyone who is on workers' comp and then retires for disability, it would not be considered regular comp, the additional pay that they were receiving, the supplemental pay. Now, this has an impact on retirement date. In particular, for example, in Vernava's case, his retirement date was set by us after he was approved for disability as the date he last received a payment of supplemental pay. But by taking that and not making it regular comp, his retirement date was actually backwards by a little over a year, I believe, to 6 months following the date of application. And so in Mr. Vernava's case, he actually ended up with a lower pension benefit and did not receive any retroactive payment. So he did not benefit from this decision very much financially. But this bill would change and say that if you were taking sick, vacation, or personal leave, it would be considered regular compensation when you're taking it in conjunction with workers' comp. It would basically be treated the same way as if any other employee just simply takes time off in the middle of their career. The next bill is an act relative to modifications of retirement allowances. This is not the result of case law. This is just, the statute is virtually unworkable in the way it is written. It's just not possible to do the modifications listed in Section 8 of Chapter 32 in the correct manner. Because what the statute says is that if someone over-earns in a given year, their retirement allowance for the next year should be modified. The problem is in the way that modification is calculated, and over-earnings in particular is calculated. If someone retires for disability, they have to file their taxes and all information with us every year. All disability retirees do. But they don't have to file that until after their taxes are due. So if someone over-earns in 2020, if they over-earned last year, we won't even see their taxes information or their information on their earnings until at least the middle of April. And in some years, if they take an extension, it could be till September, October before we see it. We won't even know that they've modified, that they should be modified until nearly the end of the year. And then we have to go through the investigation, determine the modified amount. And by that point, they're filing for the next year, and maybe they didn't over-earn. So we modify them, but then remodify them each year. It's just too time consuming. It's just not feasible. And so what we are proposing is that the modification only occur if someone substantially over-earns for 3 consecutive years, and then we would modify going forward. The next bill, and the last one that I'm going to address, is actually relative to accidental disability and Group 1 emotional distress. This is an area where we have seen disabilities that had to be denied essentially because of the group classification of the individual claiming the disability. As you know, with disabilities, a member needs to file an injury report or proof of workers' compensation, or have the injury occur within 2 years for it to be considered a compensable injury under Chapter 32, Section 7. And with emotional disabilities, what we see is that oftentimes the precipitating event occurs well in advance of when the retirement is sought. So a person could have a traumatic experience today, but not realize that they have PTSD or depression or some other emotional issue from that today's event for 3 or 4 years. And there most likely won't be an injury report for many employees because they don't know they're injured. Well, a Group 1 employee, because they don't have an injury report, they don't have workers' comp, they didn't file within 2 years of the incident, they're not going to be able to successfully claim Section 7 disability. Now, a Group 4 member would be able to if there was a report of their department involving that incident. So oftentimes with police and fire, we see incident reports from a traumatic incident that occurred. Now, the member didn't file an injury report at the time, but the incident report showing that this incident occurred Oftentimes it's a gruesome death or some traumatic event. We have documentation that existed, that member was at the scene of that incident. That is enough to satisfy the requirements of Section 7. So this would allow Group 1 employees to use departmental records and employer records to document incidents. I don't like using this example, but it's the best one that I can think of. If you have an instance of an incident at a school, perhaps a school shooting or something, and you have teachers, and you also then have police responding. Police responding 3-4 years later can claim PTSD based on that because they will obviously have an incident report. They don't have to have filed a personal injury report or anything like that. But the teacher, if they didn't file anything at the time of the incident, they were involved in the exact same situation, but they would not be covered for Section 7. It would be very difficult for them to achieve disability under Section 7. So that is the last bill that I want to go over. Bill is going to go over 3 more bills, and then we'll wrap up for the day.
Okay, thanks, Patrick. I've said to him and our other attorneys in the office that present regularly, I am jealous of their ability to just speak freely and off the cuff. I have roots in journalism. I'm used to the written word, brevity, keep it short. To just go on and talk like that, and I guess it's part of their training, but it's just foreign to me. I'm not really a spotlight person. I like to be behind the scenes, so I am definitely jealous. I feel like I'm the 9th batter in the lineup after following him bat and cleanup, so glad to have him as a wingman though. So an act relative to veterans buyback, this is something that in my time here that I've been really involved in. I really feel strongly this is a good bill, and hoping that it will pass this coming session. As most of you are all aware, that Chapter 32, Section 4 allows veterans who are in service to buy up to 4 years of credible time for their military time. There's a 180-day limit as to when that veteran has to enter into the agreement to make that purchase. And through a number of different factors, sometimes that 180-day cycle is missed, whether the veteran's transitioning to civilian life, whether their finances are not in the position to make that buyback, whether they don't know if they're going to stay in public service. It could be that they don't receive notice or aren't aware. There's a number of different things. There's no finger pointing, but and so we continue to see that it's an issue as a number of bills have passed this past last legislative session and over the last few years, allowing either individuals or groups of people to buy back their military service, notwithstanding missing that initial 180-day period. And I said there were a few individuals, but there was one last session that allowed any member in service to the city of Fall River who was a veteran to buy back their time. And there were a couple of laws that included about 2 or 3 dozen people from Chicopee. Each law specifically named a group of people, and in total it was about 2 to 3 dozen people. So it's a continued issue. They continue to get filed. So PARAC has a bill that has been filed the last 2 legislative sessions. We think it would address the issue holistically. 2 legislative sessions ago, it was reported favorably by Public Service, and it was amended by Public Service to incorporate a one-time, 1-year grace period for any veteran to buy back their military service if they hadn't already done so. The other component of the bill is it would extend the time to enter into the agreement to within 1 year after vesting, so effectively 11 years. The time for completing the buyback would be ultimately up to boards upon such terms and conditions as the board may prescribe. We pushed this bill. We were hoping that last Memorial Day, it would be included in a special veterans bill. Each Memorial Day, Veterans Day, there's often special veterans bills the legislature pushes. And then the pandemic hit and things kind of came to a stop. And then back in the fall, there was hope that there was going to be a Veterans Day legislative bill, but the focus was really on the budget and coping with the pandemic and how to meet, and there were a host of issues. So that didn't happen. But in the Senate budget, Senator Mike Rush, who is a veteran himself from West Roxbury, he sponsored our bill as an amendment to the Senate budget. We had a cross section of senators co-sponsor it across both parties from all different parts of the state. Senator Timilty of Milton, chairman of the Senate Veterans Committee, was one of the co-sponsors. So there's definitely momentum behind it. It didn't pass. There's, I think there's nobody was sure why it didn't come out of the House, and the Senate is reluctant to, step on the House's toes. But so now, this session, we're hopeful that whether it's through the budget or on its own or through a veterans bill, that this bill will pass. There's been a good amount of support for it. There's no cost to it. And I just think it's a good piece of legislation that helps people that deserve it, and it rectifies a situation that needs addressing. And hopefully we'll see it pass in this coming session. This other bill, that's a new bill that we filed this year, an act to protect gender pay equity. I also think this is a great bill that addresses a serious situation that needs addressing. The Mass Equal Pay Act, Chapter 177 of the Act of 2016, it prohibits wage discrimination based on gender. Seems fairly straightforward. One of the conditions of the bill, and there are regulations from the Attorney General's office that spell out how to conduct a study and how to determine if there is in fact wage discrimination. But one of the conditions is if there turns out to be a discrepancy in pay based on gender, the way to rectify it is not to reduce somebody's pay, but to increase the wages of somebody that's been negatively affected. So that's spelled out in statute. The MWA Retirement Board actually made PARAC aware of some members who had their pay increased as a result of gender pay equity action, and they were bumping up against the anti-spiking provisions. And clearly the intention of the gender pay equity law is to raise people up and have a level playing field and have equity. To then be penalized with anti-spiking seems to go against the intent of the law. Actually, can you bump to the next slide? Thank you. So there are a number of exemptions to anti-spiking. None of them address what the situation is here in the gender pay equity law. The gender pay equity law does not specify a salary, so that exemption wouldn't work. So we think that to create an exemption, another exemption for actions taken relative to salary, relative to the pay equity law, would be worthwhile. And that's what the bill is. It creates an exemption to anti-spiking for any salary increase tied to the Equal Pay Act. So we're hopeful that that law, that bill will move forward. I think it's something that people will support. I think it makes sense. So be interesting to see how that goes going forward. One other bill that we filed is also a new bill this session, and it's based off of what we did a couple years back with continuing education. We had seen that there wasn't flexibility for the commission to handle continuing education issues or any hardships. So in 2018, a bill was passed to give the commission the ability to take a hardship waiver and have some flexibility in how they deal with members if there's an issue related to continuing education. And this bill would do the same for statements of financial interest. There has been one case anyway where somebody had a hardship and came to the commission and there wasn't a lot of leeway. So this bill would give the commission the ability to take a waiver application from a board member who was late or hadn't filed their SFI, provided the person does come into compliance and it's extenuating circumstances. Again, it's just the ability to have some discretion and have a little gray area, that not everything is black and white. So hopefully that's something else that will get support and will pass. So that's our legislative package. I don't know if Patrick wants to jump on here for the little wrap up, but we're just going to give a little brief update on some of the latest things going on in the legislature. Just yesterday, the governor filed his budget, first step in the budget process. It seems odd that just the end of December, beginning of January, the legislature was doing budget veto overrides. But that was the nature of the pandemic, and the session, the legislative session had formal sessions right up till the very end, which is highly unusual. Usually in the second year of the session, formal sessions end at the end of July. So this puts it back on track. You know, this is the first step. The governor's budget is filed. The House Ways and Means budget comes out usually in mid-April. That gets debated, amended. Then the Senate budget comes out in May. And then the two chambers go into a conference committee to come up with one document that goes to the governor. The idea is to have it to the governor and to get it signed by July 1st, the start of the fiscal year. That doesn't always happen, as we saw this past year. There were a number of temporary budgets put in place. It went deeper into the new fiscal year because of the pandemic and the unsurety about revenues. But typically the budget comes into place come July or August. But so that's the first step. In terms of retirement, the COLA was included for state and teachers. Not a huge surprise, but last year with the state of affairs, there was some question as to whether the COLA would be in there. It was. So basically, after it being in there last year, it was fully expected to be in there this year, but always want to confirm. Again, that's just the first step. Don't expect the House or the Senate to remove it or to alter it, but it doesn't become law until the House and Senate pass it and the governor signs it. So, but good first step. There's a full pension payment in there, 3.415 billion. So, you know, last year with the crisis, there was some discussion of maybe altering the schedule. That didn't come to pass, and things seem to be hopefully picking up. Although there is provision in the budget the governor filed to allow for continued withdrawals from the rainy day fund. He doesn't necessarily expect to use them all. His staff thought that if between what's used this year, which they also don't think they're going to reach the limit of what they authorized, and what he's proposing for fiscal 22, he's saying that there'd be about $1.1 billion left in that stabilization fund for fiscal 23. But again, that's down the road a little bit. As you're all probably aware, there's a new speaker. Speaker Bob DeLeo resigned right at the end of December. His majority leader, Ron Mariano, is the new speaker. They're in the process right now, both chambers, of coming up with rules for this session. He's in the process of naming his leadership team. Some of it may not change, but there were some folks that retired that he'd be filling spots. He might be shifting people around, so there'll be some changes in the House. The Senate is in the same leadership. Senator Spilka still the Senate president. Don't expect to see much change there. But in the House, there should be some new leadership positions. Both chambers will be naming their committee chairs and naming reps and senators to committee assignments. Again, they're not exactly sure how many changes there'll be, but it's always something to look for. The Public Service Committee is the committee that we most closely work with. Any type of public service bills, retirement, pension bills go through public service. I think we expect to see new chairs on both sides, the House and the Senate. House Chair Rep. Jerry Paracella has been there for a couple of terms. He's great. Not that we're trying to push him away. We'd love to see him stay, but think that he may be moving up the ranks. Usually that's kind of the path. People will do public service for a couple terms and move on. He may still be there, we don't know, but we think we might have a new House Public Service Chair. And on the Senate side, Senator Feingold came in late in the second year of the session because of some administrative decisions that had to take the prior Senate chair off. He already had some other chairmanships, so I think we'll have a new Senate chair also. And then with just the way that the last session went with the pandemic, both chambers have voted to push back the bill filing deadline. It would have already passed the third Friday in January. They voted to push it back to February 19th. So legislators can still file their bills. Agencies like PERAC, we had to file by November. That didn't change. But legislators are allowed to still file bills through February 19th. So between that and committee chairs and assignments still being done and leadership positions, I don't think there's going to be a lot of movement in terms of bill hearings and bills moving forward or being reported favorably, later into the spring. And then just to talk about looking up bills or just giving a couple of resources for folks. Both the House and the Senate Clerk's Office, if you know bill numbers, you can search them. Just a little thing that I learned, if you search them on the legislature's website, put the letter with the number, like H1234, don't put a little space in there, keep it together, makes it easier. You can do keyword searches. In either case, when you look at the search parameters, check to see that you've selected the current legislative session if you're looking for a certain bill in that session, or else you're going to get a host of bills from a number of different sessions which you might not want. Or if you're looking for a law, you can click on that law parameter just to look for a law. It can be bulky, it can be unwieldy, but there is a wealth of information there if you ever need to look something up. And certainly feel free to reach out to either of us with anything legislative that we can help out on. So I think that does it for me. Patrick, you have anything else?
No, I think we'll just see if Natasha has any questions for us.
Okay.
Yes, we do have a few questions. So the first question received, maximum age. Just to clarify, even if a police position is not eligible for membership in the retirement system, that position or officer is mandated to retire at age 65 unless special legislation is filed specifically to the person.
Yes, that is our understanding. The HRD rules is for a uniform member of a police or fire department. It does not specify that they have to be a member of the Chapter 32 system. I understand that there's some confusion sometimes because the maximum age definition is actually in Section 1 of Chapter 32, but the actual requirement is not specific to a Chapter 32 system.
Yeah, it's Chapter 415 of the Acts of 1987.
Okay. Next question. When we discuss pension forfeiture, is there a distinction between a disability pension and a superannuation portion?
Not for purposes of forfeiture. There is a distinction in that a person who's on a superannuation retirement and is in prison can continue to collect their benefit, but a disability retiree who goes to prison for something completely unrelated to their job, mind you, they cannot receive their benefit while they are in prison. But otherwise, there's no difference for forfeiture purposes. If the person commits a crime relative to their officer position, both pensions would be forfeited.
And can you give the House bill number regarding the Vernava regular compensation decision?
I don't believe our bills have been given numbers yet. We won't get numbers until the clerks in both the House and Senate have accepted all of the bills. So that usually doesn't take place for another month or two.
Okay. If the act relative to wages passes, it essentially reverses Vernava. Many retirements have already been calculated pursuant to this case law. Is there language in this bill that makes this strictly prospective and does not allow for the retiree to request a new disability pension calculation?
That's an excellent question, and I don't off the top of my head remember if it is in the bill or not. I'm not sure. Let me take a look while we answer other questions. I have it in front of me here.
Okay, thank you, Patrick. Next question. What is the process for restitution from accumulated deductions under the forfeiture bill? Do retirement boards make the decisions regarding the appropriateness and amount of restitution?
If the member can request that they make restitution from their account. And so then the board would determine what is in the account and whether there is sufficient funds to do that.
Why has the passage of the forfeiture bill not been successful, especially where the SJC's Betancourt case encouraged legislative action?
That's an interesting question. It's an excellent question. Unfortunately, I can't answer it, but there's 200 members of the legislature that should be asked the question because I think it's an excellent bill to pass. I think that part of it is there's a reluctance on, frankly, reluctance to do anything that looks like it's weakening a statute like the forfeiture statute. The fact is, right now, the forfeiture statute is extremely strict. It's one of the strictest in the entire country. And any bill that modifies that is going to be seen by some people as a weakening, as a caving to public employees, which, I mean, I think is partially ridiculous simply because the SJC has told us part of your law is unconstitutional as applied to certain individuals. So some people are not going to be allowed to be forfeited. And so then you're going to have people getting their full pension. We've seen it a few times now. I believe there's 3 or 4 cases that I'm aware of where someone has gotten their benefit because of the 8th Amendment, other than Betancourt. But I think that we need more, to get movement, we're going to need more high profile cases. And so, you know, if some state troopers start getting their pension, I think we're going to see some movement, but I don't know.
Yeah, I think that's exactly what Patrick said. It's a political question, that it's perceived as weakening something, right? You get no pension now. To allow some of it is sort of perceived as weakening it. But when something's ruled unconstitutional and then they get their full pension, then this bill would be a better alternative where there's still some penalty, but it's still constitutional.
With respect to the wages bill, there is nothing in it. It is a very brief bill. There is nothing in it that would allow for retro changes to a member's benefit. You retire under what the state of the law is at the time of your retirement. So if there were going to be any modifications for current members or members that have retired since the Renave decision, that would have to be added to the bill at the legislature.
Thanks for looking that up, Patrick. This next question, I think it's a 2-part question, but I'll read it and then I'll read the next one and then you can tell me. It says, I am confused with Chapter 91. Next question says, who determines the payback? Is it on the local level or by PERAC?
So Section 91 is, I'm assuming they mean Section 91 of Chapter 32, and that is all determined at the local board level. Boards and the local employer and member are supposed to track earnings for 91. 91A is where PERAC steps in, and that's for disability retirees. And we do review all disability retirees' earning statements. Now, there is a class of disability people that have been retired for so long and have had no earnings that they don't have to file any longer, but we still have well over 10,000. I think it's closer to 15,000 people that have to file for disability, their earnings. And we review that and determine the amount we think, but it's the board that ultimately must do it through a hearing and determine what the amount is owed.
Okay. And I don't think we have any additional questions.
I actually received an email with a question because they were having trouble with the chat feature. In view of the IRS private letter ruling in 2013, that's actually a reference to PERAC requested the IRS provide us with a private letter ruling on the taxability of certain benefits. And in particular, it addressed Section 6, 7, and a couple of other sections and beneficiary sections under 9 and 12 2D, and whether the payments made under the sections were taxable at the federal level. So the question goes on, is the amount over 72% set forth in special legislation for disability taxable? And also, is the return of accumulated deductions taxable? The answer to the amount over 72%, so if we're doing a special disability bill where the person gets 100%, whereas under Section 7, they'd only get 72, no, it is not taxable. It is, as long as it is referenced as a disability pension, it is treated the same as a normal disability and be non-taxable at the federal level. But the return of accumulated deductions, essentially the annuity count, is always taxable. And so that does not change. It will be taxable at the federal level. We actually had a second question from the same person with reference to special legislation extending the maximum age beyond 65. If the member becomes disabled, is ADR available and can the presumptions be invoked? If you go back to those special disability slides, if you look back at your packets, you'll see that usually it says that upon retirement, the member will get the super that they would have gotten as if they had retired at age 65. That forestalls the disability after the fact. Now, there is a question, and I don't know 100% the answer to this, regarding presumption because of the cancer presumption. The cancer presumption is the only one that does not require you to be disabled as of the date of retirement. And so we often see people that have retired for super at age 65, but then at age 67, they get diagnosed with cancer if they're firefighters, and they can get the disability. I don't know that the special legislation has any effect on that, other than perhaps that the 5 years would run from age 65 rather than from the actual date of retirement. But I'm not sure, we've never seen that situation, so I can't say how we would address it for sure. That's the last question that I have here.
Okay. Well, thank you everyone for joining us today. Thank you, Patrick and Bill. You guys gave an excellent presentation. You will be receiving an email with a link to a survey to provide us with some feedback on today's presentation. We would appreciate your feedback, so please fill out the survey and let us know what you thought. Give us any recommendations on how we can continue to improve these offerings. I hope you have a great rest of your day. Thank you for joining us today.
Thanks.
Thank you.